All right, we're going to go ahead and get started. Good afternoon, everyone, and thank you for joining us. My name is Brooklyn Mars, and I serve as the Director of External Affairs for the Indiana Civil Rights Commission. As part of Fair Housing Month, today's conversation is focused on clarifying the differences between service animals and emotional support animals in housing, while providing practical guidance for both tenants and housing providers. We know this area is where there is a lot of confusion, and our goal today is to help bring clarity, share accurate information, and support better understanding on all sides. Now, before we get started, I want to take a moment to review a few quick housekeeping items. Closed captioning is available for today's webinar. To turn on captions, click the More button in your toolbar. Select Settings, then choose Accessibility. From there, you can toggle the captions on. We will also have time for questions at the end of the session, so please feel free to submit those throughout the presentation. Following this panel, you will receive an email with a link to the recording. The recording will also be available on ICRC's YouTube channel. And I am so sorry, give me 1 second, my internet is being weird. Okay, my apologies, everyone. Following this panel, you will receive an email with a link to the recording. The recording will also be available on ICRC's YouTube channel, @IN Civil Rights, in the coming days. Before we begin, I'd like to take a moment to introduce our panelists for today's discussion. If our panelists could just turn on their cameras for us so everyone can put a face to a name. Thank you. All right, so first we have Chase Lovely, a REPACE investigator with the Indiana Civil Rights Commission. Chase investigates discrimination complaints related to housing and will share insights on trends we're seeing across Indiana. Next, we have Scott Kreider, Deputy Director and General Counsel at the Indiana Civil Rights Commission. Scott is going to walk us through that legal framework and help clarify what housing providers may and may not do under the law. And finally, we have Sean Diamond, Vice President of Programs and Operations at the Indiana Canine Assistant Network. Sean will offer insight into the real-world experiences individuals encounter when requesting accommodations. We are so grateful to have each of them here today and for their willingness to share their expertise. Now, to begin, I will go ahead and turn it over to Chase.
Thanks, Brooklyn, and good afternoon, everybody. My name is Chase Lovely, and I'm an investigator with the Indiana Civil Rights Commission's REPACE division. And in today's Fair Housing panel, we'll be discussing emotional support animals and service animals in housing. And then before beginning, can give a disclaimer that the Indiana Civil Rights Commission doesn't make the laws. We're an enforcement agency, so the general information and guidelines discussed today shouldn't be taken as legal advice or considered as official Indiana Civil Rights Commission policy. For legal advice on service animals and emotional support animals, please contact an attorney. As previously mentioned, the Indiana Civil Rights Commission is a civil rights law enforcement agency. The statutes the Commission is governed by and what we're authorized to enforce are contained within Indiana Civil Rights Law and the Indiana Fair Housing Act. Our mission in enforcing these laws is to safeguard the public's best interests and to eliminate discrimination in the state of Indiana. We accomplish these objectives by receiving and investigating citizen complaints of alleged discrimination. These investigations fall within the enforcement areas that are under our jurisdiction, which are housing, public accommodation, credit, education, and employment. ICRC also serves as a public resource, providing education and outreach as a preventative measure as well. And then in housing enforcement, a complaint can allege discrimination on the basis of any protected class within the state of Indiana. The most frequent alleged basis that we receive is disability. The Indiana Fair Housing Act defines an individual with a disability in a few different ways. This can be someone with a physical or mental impairment that substantially limits or one or more major life activity. This can be someone who has a record of such an impairment, or it can be someone who is regarded as having such an impairment. Allegations of disability discrimination can relate to various aspects in housing, but many concern a reasonable accommodation issue. This can be the outright refusal to accommodate, refusal to rent after communicating a need for an accommodation to a no pet policy, pet fees being charged for an assistance animal, or the refusal to participate in the interactive process for an accommodation request. ICRC's goal is to clarify guidance on accommodation and other housing-related issues for tenants and housing providers alike, ultimately promoting compliance with relevant laws and equal access to housing. So the Indiana Fair Housing Act defines a reasonable accommodation as a change to a rule, policy, procedure, or practice which may be necessary to afford a disabled tenant or applicant the equal opportunity to use and enjoy their dwelling as someone without a disability would. An accommodation can be made to many different policies that a housing provider may operate, so long as that request is reasonable. The reasonableness of the request considers factors like if the accommodation has an identifiable relationship to the tenant's disability, if the policy as normally operated limits that tenant's equal access, as well as the feasibility of an alteration to the policy. Once an accommodation is requested, both the tenant and the housing provider have a duty to consider these factors by engaging in a good faith effort through the interactive process. The interactive process will be further detailed in the next panel by ICRC's Deputy Director Scott Kreider, but generally this process includes the tenant providing documentation showing their disability-related need for the accommodation, and the housing provider working to determine how they can accommodate the tenant. Relevant to this panel, an example of a reasonable accommodation would be a requested alteration to a housing provider's no pet policy. And then to better understand the no pet policy accommodation issues, tenants and housing providers must first understand what the alteration would look like. These accommodations can't be made for pets, but they can be requested for tenants to reside with either a service animal or an emotional support animal. And while these are often regarded as one and the same, there are some key differences between emotional support animals and service animals which influence the interactive process. So for service animals, these are specifically dogs that are individually trained to perform disability-related tasks for the benefit of someone with a disability. Depending on the impairment, medical providers may recommend someone with a disability to have a trained service animal to perform a variety of different tasks. This can be a seeing eye dog for someone with a visual disability, a mobility aid for someone with a physical impairment, or an alert dog for seizure response. And while service animals must be a dog, emotional support animals are not confined to that limitation under the Indiana Fair Housing Act. And furthermore, ESAs aren't trained to perform a disability-related task, but are prescribed by medical providers for their therapeutic benefit to someone with a disability. The therapeutic benefit of an emotional support animal similarly depends on the individual, but through dedicated companionship and comfort, their purpose is to alleviate the disability or mental health related condition. While these differences exist between the two, compliance with the requirements of the Indiana Fair Housing Act remains. So neither service animals or emotional support animals are regarded as pets, since they are both recommended by medical providers as necessary aids to alleviate disability-related symptoms, in the same vein that a hearing aid for someone with an auditory impairment would. And because of this necessity, the Indiana Fair Housing Act recognizes a disabled tenant's right to reside with either a service animal or emotional support animal when it is properly documented. And while all complaints are unique, there are some concerns that tenants consistently raise against housing providers in the complaints that we receive. A common factor from the perspective of housing providers is not intentional discrimination, but a lack of understanding on what differentiates service animals from an emotional support animal, as well as what is required of them by the Indiana Fair Housing Act. In turn, this can create misguided decisions in the interactive process for tenants' unique reasonable accommodation requests, clouding the good faith effort towards a resolution. As with many of the investigations I've personally had, this can come in the form of improper charging of pet deposits or pet rent, which has become an emerging issue after the withdrawal of federal guidance on emotional support animals. And even with withdrawal, this under the Indiana Fair Housing Act, charging pet fees or pet deposits for an emotional support animal is still prohibited, just like it is with service animals. There is also the issue of what quantity and quality of documentation affirms a tenant's disability-related need for an accommodation. Housing providers may have never had a tenant request a no pet policy accommodation, so they may demand materials that are beyond the scope of establishing a disability-related need or that is burdensome for the tenant to provide. How online service animal or ESA recommendation letters are viewed is another prevalent issue. Some may have a recommendation from an online medical provider for many reasons, and while discerning the validity of these verifications should be exercised, a denial in absence of further fact gathering to understand a medical provider's knowledge of the tenant's disability is an unreasonable assumption. Decisions by a housing provider can also be influenced by the underlying motive of over-relying on no pet policies, even when a tenant has shown an accommodation is necessary. Prioritizing uniformity across the property regarding the enforcement of a no pet policy puts housing providers at risk for potential liability. And then investigations also show that misunderstandings on accommodation requests similarly extends to tenants as well. Because many aren't aware of the differences between emotional support animals and service animals, tenants often use these titles interchangeably. And even when it's unintentional, it's a fundamental issue that can result in a complaint being filed for something that could have been avoided altogether. And confusion can also stem from tenants conflating the rights defined under the Americans with Disabilities Act with those under the Indiana Fair Housing Act, even though that they differ in application requirements and enforcement measures. There's also misinformation on the validity of online certificates and recommendations, which strongly impacts confusion, as many tenants aren't aware of what the Indiana Fair Housing Act considers to be reasonable documentation establishing their disability-related need. Companies may tell tenants that their recommendation is all that they will need to provide, even though it was given for a fee and without having knowledge of their disability through ongoing treatment. This can lead tenants to believe that their housing provider is in the wrong for asking for further information, even though the housing provider is well within their right to verify disability-related need for the accommodation, as is a part of the interactive process. Further expanding on that point, there's also a lack of clarity on what documentation housing providers can reasonably request. For example, many complaints raise issues with questionnaires for accommodations they requested, believing that the questions are invasive into their disability rather than being geared toward establishing that disability-related need. And another factor is that the Indiana Fair Housing Act doesn't offer a uniform or standard procedure for accommodation requests across all housing providers. Tenants may highlight experiences with prior housing providers who had a less stringent interactive process, leading them to believe that their current housing provider is discouraging their accommodation. And the Commission recognizes these issues and seeks to address the confusion surrounding service animals and emotional support animals through education and outreach, thus avoiding the conflict altogether. And then through this education and outreach, ICRC strives for a better understanding of how the Indiana Fair Housing Act applies to service animals, emotional support animals, and accommodation requests. Clarification leads to more clear policies being implemented for more informed decisions, thus reducing conflict resulting in filed complaints. Housing providers would also be better protected from liability for accommodation-related issues, and tenants would have the strengthened knowledge of their rights. And more consistent and fair practices that are compliant with the Indiana Fair Housing Act mutually benefit both parties, as tenants don't want to feel discriminated against, and of course housing providers don't want complaints filed against them. And then the Indiana Civil Rights Commission is dedicated to our mission of eliminating disability discrimination regarding assistance animals, but our mission also extends to other issues, protected classes, and areas of enforcement that we mentioned earlier. The statute of limitation to file a housing complaint is 1 year, So if you or anyone you know believes that they have experienced housing discrimination, please contact the Indiana Civil Rights Commission to file an inquiry through either our website, phone number, or address that's listed below. And thank you again for your time today.
Perfect. Thank you so much, Chase. That was a really helpful overview and really a grounding in what we're seeing in practice. Now we're going to shift into what the law requires and how these situations are evaluated from a legal perspective. Scott, I will go ahead and turn it over to you.
Thank you, Brooklyn, and thank you, Chase. Again, I'm the Deputy Director and the General Counsel for the Civil Rights Commission. What that means is just I wear a bunch of different hats. So everything from our operations to also overseeing our legal team. So today, as noted, I'm going to try to give you a high-level overview of the law as it pertains to this area. Again, here's the disclaimer. Nothing today is intended to be for legal advice or official policy of the state of Indiana or the Civil Rights Commission. It's just for information, educational purposes. If you do need legal advice, I just stress, please, please, please seek an attorney before you act. We often say it's better to beg for forgiveness than to seek permission, but that's not true in the law. Always seek an attorney in advance if you can. It'll help prevent some problems in the long run for you, potentially. So as Chase noted, fair housing, it's basically designed to make sure we have equal access for everyone. It's required under the law. It's prohibited or designed to prohibit discrimination based on protected classes, particularly for disability. Believe it or not, that is actually the #1 protected class that we see here at the ICRC is disability, both in housing and other contexts. And housing providers have to provide reasonable accommodations when they're needed, requested, and if they're able to do so unless there's an undue hardship. And assistance animals are a large part of that accommodation process. How the law views assistance animals, Chase kind of noted this, they're absolutely not considered pets under the law. And it's important if you do have one that you don't refer to it as a pet. Don't check the box on an application that it's a pet. It's an assistance animal. And it comes in 2 different types, service animals. Those are mostly dogs. There is an exception also for miniature horses, but those again are animals that are trained to perform specific tasks, as opposed to an emotional support animal, which could be a cat, could be other animals. Those are designed to provide support or comfort for the disabled person. For housing, they're treated fairly similar. Outside of this context, though, in public accommodation like a restaurant, you will find that there is greater protection often for the service animal as opposed to the emotional support animal. But the key question in housing is whether that animal is needed for a disability. So along those lines are things that a housing provider can and cannot ask, things that they may ask about. Is the animal needed because of a disability? And then what disability-related need is that animal providing? Housing providers can also ask for documentation. That's not asking for your entire medical history, but it is asking for some reliable documentation in some cases. Ultimately, all the questions that the housing provider asks should be what is necessary to evaluate your accommodation request. And when you make the request too, I would add, ask for an accommodation on any pet policies, pet fee policies. Makes it more clear that you have an assistance animal if you ask that as part of the accommodation request. What they may not ask about or what they may not do. I think Chase noted this pretty well. You can't charge pet fees or deposits for assistance animals. You can't apply a blanket no pet policy. That would absolutely be prohibited. You can't go into asking for excessive or the full history of someone's medical records. And you can't be inconsistent in how you apply your rules. You need to treat each tenant fairly and with respect. Next slide, please. This is just some scenarios of what it would look like in the real world. Keep in mind every case is going to be different. It's going to be dependent upon the facts and the circumstances. But as a general rule, it should not deny an accommodation request because of a no pet policy. That may be a violation. They should never be charged a pet deposit fee. We can't stress that enough. It's, again, as Chase noted, that's one thing that comes up quite a bit with emotional support animals. Again, cannot request your complete full medical history. They just need to ask for, what's there to evaluate disability and the need for the animal, and that's pretty much it. And then just don't dismiss online documentation out of hand. There's sometimes that does come up as an issue, whether it's fraudulent documentation or not. They need to look at it and evaluate it thoroughly as part of their investigation, and not just simply dismiss it because you provided something that was online. So next slide, please. And what does the accommodation process look like? So we've tried to map it out here. This isn't necessarily set in stone. Just keep in mind there's a process. We've kind of tried to map out what an ideal situation would look like. It starts with the tenant making the request for the accommodation. I would suggest that anytime you make that request, also ensure that it's documented, whether you have to send a follow-up email or a text message. The housing provider should acknowledge that, again, documented in writing in some form. Make sure they review it. I would start that process as well very early. Don't wait weeks, don't wait days. They should immediately proceed with acknowledging the request and reviewing it. The next step would be reviewing and providing documentation, reviewing that to see, again, if the animal's, if there's a disability, confirm that there's a need for that animal. And then engage in a good faith conversation, hopefully one that's calm, one that's professional. Try to determine whether the accommodation is something that can be provided. If it's not, see if there's alternatives that can be explored, and explain those thoroughly back and forth and have that dialogue. And ultimately, we hope that an accommodation or some form would be granted so that equal housing would be provided and supported. So when do legal issues arise? Chase noted this, it's generally not a matter of intent. It's somewhere the process just breaks down. So whether that's a blanket denial without review, applying a no pet policy across the board, asking too many questions or not understanding the documentation process, or just not engaging in the communication process with a tenant. Again, just if you follow the process, it makes things a lot easier. It also eliminates cases that arise in our office. Best practices in for housing providers, as I said, make sure you always document everything, but evaluate on a case-by-case basis. Be consistent in your application and enforcement. Be very clear and respectful at all times in your communications. And again, if you need guidance, if you need assistance, make sure you ask for it. Don't be afraid to do that. And why does it matter? Again, if we can reduce the amount of complaints, we reduce discrimination in general. People feel more respected in that process. Just more harmonious relationships among the tenants, the housing provider. Ensure that fair housing laws are met and that everyone can live a more productive life. Keep in mind, too, the law only sets out some basic framework. Not everything that happens that we want to say is discrimination necessarily something that the law provides protection for. It's not necessarily something that we can enforce. One thing, for example, we're not there to enforce bad manners. We can't necessarily dictate that. So not everybody is going to have the most polite manner. We would hope that would not be the case, but that's not really what we look at and not what we're here for. And again, if you have questions, if a complaint does arise, remember you do have 1 year to file a complaint in the housing world. You can do that online. We have a portal on our website. You can give us a call. You can also walk in. We do take walk-ins. So thank you again for everyone. Appreciate your time today.
Thank you, Scott. So we've now heard the legal framework and what housing providers need to understand from a compliance standpoint. It's just as important to understand how these situations impact individuals in real life. So now I'd like to welcome Sean Diamond from the Indiana Canine Assistant Network.
Thank you, Brooklyn, and thank you for inviting ICANN to be a part of this panel. Chase and Scott did such a great job. I'm here. I'll explain what Indiana Canine Assistant Network ICANN is and how this, and at the end we'll tie this into how we approach any housing issues or discussions and education. ICANN's mission: we advocate for independence and opportunity by facilitating partnerships between people and dogs to unleash possibilities. So what is ICANN? So ICANN was founded in 2002. We are also the only Assistance Dogs International accredited organization in Indiana. And we provide individuals living with a disability greater independence and an opportunity for a more enriched life by placing with their service dog. We also provide education and rehabilitation to incarcerated individuals. We are in 3 Indiana correctional facilities, and we do most of our training inside the prisons. They're there for 2 years, and they go out every 6 weeks with our volunteers for a 3-week period. So we are trying to assist the incarcerated individual also to move forward. So service dogs help people who live with all kinds of disabilities, and ICANN itself trains dogs to help with the following. Mobility assistance and psychiatric services for veterans are the public access dogs. We also place facility dogs in schools, occupational rehab and such, and in-home skilled companions. And here's where the cost comes in. As a nonprofit, it's always interesting to see how much it costs to train one service dog. We currently have 50-some dogs in training, and to train one service dog costs ICANN just around $32,000, and that includes everything with training, veterinary care, food, equipment, and the such. We only charge individuals $2,900. Eligible veterans, as it states, do receive their dogs free of cost. They gave to us. We want to give back to them. We will work with the clients on the fee if we need to have some payment services. We do want to provide the dog to the individual that wants and needs one, but we also want to see that our dogs are going to be taken care of, because as a lot of you know that have pets, they're not exactly cheap at times. So we want some skin in the game and to show that you can take care of the dog. So here's some differences, and I know, and Chase and Scott alluded to some, and when you look down at the housing where they live with their handler, even if a no pet policy in place, only public access service dogs and emotional support dogs are eligible. So facility dogs, which ICANN places is that works in a facility, aren't technically service dogs. They aren't under the American Disabilities Act, and so they don't have that access. And same with therapy dogs that many of you know that may go to a nursing home, a hospital, or such, and provide some therapeutic value. But there is a lot of confusion around what is the difference between service dogs and emotional support dog. What is the difference between emotional support dogs and therapy dogs? So education, and as Chase and Scott mentioned, education is important, and that's something that our community engagement team is wonderful at, and they get out and discuss this. The more education we can do through the community, the less issues individuals with disabilities or individuals that have a service dog will encounter. Next slide. Yeah. So for ICANN and living with a service animal, there's several things that play a part, not just the American Disabilities Act, but as Scott mentioned, the Fair Housing Act. What are the rights of housing providers? And that's Chase mentioned it and Scott alluded to it. You know, Chase said misunderstanding rather than intentional discrimination is usually the issue, and that's what we found out in housing and in just the public access of service dogs. And so how we approach them, how we teach our volunteers, clients, and how we proactively get out there with our community engagement team and talk to businesses, talk to landlords, and get them the knowledge of what are their rights. I would say, you know, I get it when a business owner or a landlord has had a lot of confusion of, is this a service animal? Does it have the public access rights? Does it have the fair housing right? Is it under the Fair Housing Act? And they can get a little frustrated themselves, you know, when things don't go well, and then an individual with a service dog that is maybe accredited by us goes into a place and there's some resistance from the business owner. There's some resistance by the tenant. And I tell people, I get it. As a human being, I get it. So how do we communicate to them. And as Chase and Scott alluded, it's education proactively, and it's how we approach them when there is an issue in terms of non-confrontationally, and how do we sit down and have a discussion about this. So all these play a part in living with a service animal. Their issue with housing and other public access issues is proactive education. I think it's more and more that's the focus. And then when we respond to issues, which many times is myself, is really just having a discussion and understanding, do they know the law? What really happened in this situation? How did we play a part in this escalating? And having just a discussion about it, and that goes a lot better than assuming that it's all on that landlord or business owner. Next slide, Brooklyn. Is there one? So if you want to donate or volunteer, icandog.org. Like I said, we are a nonprofit. We do want to place service dogs with individuals with disabilities, but as you saw, about $32,000 for one dog in training. And if you're interested in applying, you can go to our website too and inquire, or give us a call or an email. Thank you.
All right, thank you, Sean. At this point, we're going to move directly into audience questions, and I'm going to start off with one from you guys. How do we handle pet allergies in a condo building? Can we restrict certain areas with less traffic for the emotional support animal? And panelists, I will have you show your faces pretty please for this part. I think a few of you might be able to weigh in on this answer.
So I can weigh in on service animals, assistance animals such as service dogs or guide dogs. Allergy is not it's not you can't put them like in a restaurant in a corner away from everybody or in the kitchen. In a landlord tenant situation, it's almost a form of, you can't make it discriminatory because of a supposed allergy and how that is. I don't know what Scott or Chase can add to that, but in terms of public access animals in public, that you can't deny them or restrict them in any way. Oh, that's it.
Yeah, that's a good question. It's not something I've encountered before, but I think it would be like any other situation where other tenants raise concerns about the animal, whether it's noise, something like that. It's a fine line of balancing between making sure that you are accommodating the request for the accommodation and respecting the need for that animal, while also kind of ensuring safety and enjoyment of the other tenants. So, the first thing is, I guess, is exploring that complaint, making sure what's valid, and then exploring the options, making sure you include the person, both sides into that conversation, and see if you can find an accommodation that will work for everyone. Obviously, you can't. If you're harming the person with the allergy, then that's going to raise a complaint there as well. So you got to try to balance that issue, I think, at the end of the day, and try to find some sort of solution if you can. And often there will be one, if that means, trying to find a different, spot within the housing unit. Maybe you would have to put in some kind of air conditioning, something like that, to try to prevent that issue from spilling over to the sensitive tenant.
Perfect. And then I think this next one kind of goes hand in hand. But what about damage or destruction? Relieving themselves within premises, wagging tails, breaking goods for sale. So I'm thinking they're talking about you bring your service animal into a store and something is broken.
The client or the client's responsible.
Yeah,
Yeah.
I'd say that's the same under the housing. Yeah, go ahead, Chase, if you want.
Oh, sorry. So yeah, I was gonna say, for as far as damage to the property and housing, even if you have a service animal or emotional support animal, you would still be subject to the same terms and conditions as any other resident would be under the lease. So you would still be liable for any damages or destruction caused by your service animal or emotional support animal. So that wouldn't really change.
Thank you. And then I will direct this one to Sean. Can a tenant train their own dog to be a service animal?
So yes, technically anybody can train their own dog to be a service animal currently. Um, we've all heard over the years about fake service dogs or whatever you want. I don't like the term fake, but inappropriately trained service dogs. And but anybody can train their dog. I will say, if you're a veteran and have to access the VA, you have to have a service dog accredited by the Assistance Dogs International or International Guide Dog Foundation. So that is pretty new in the last year. And when you have to understand that if you train your own dog, if you're going overseas mainly is going to require Assistance Dogs International accreditation for travel nowadays. And also understand that dogs that are inappropriately trained, as we ask, and the business can ask them to leave, or or they're tearing up the apartment. I mean, under the lease, there's some options there for the tenant. How that presents to the next individual that has a service dog that really needs a service dog, and how that resistance can come up by the business owner or the landlord, which is natural, as I mentioned. But anybody can train a service dog currently. I'll speak today. Yes.
Perfect. Thank you. All right, next one. Many housing providers are now requiring persons with disabilities to fax their medical professional in order to approve their reasonable accommodation request for their animal, even though they have already provided sufficient documentation of their disability and the need for the animal. Can you speak further to these mandatory ways to request a reasonable accommodation housing providers are adopting?
Yeah, I'll go ahead and try to address that question. So, again, keep in mind that the landlord, the housing provider, they cannot request your entire medical history. It's going to be somewhat fact sensitive. What did you provide them initially? Was that enough for them to do the evaluation or not, to determine, one, disability, and then two, need for the animal? If that's there in your documentation already, that's going to be something we're going to closely scrutinize as kind of exceeding the bounds of what may be permitted. But it could be something that maybe there's an issue with one of the documents that you did provide. Maybe there's an age issue, something along that, and they want to confirm that actually was your doctor that provided it. So that could be maybe the reason that the housing provider's requesting something more. So it's just going to be kind of fact specific.
All right, I have another one here. I heard from several condo owners that have emotional support dogs are changing the dates on the documents illegally. How do we get around that?
Yeah, again, I'm not sure what's happening there, but if you're altering dates on a document, that's basically fraudulent. I'd say that's an absolute no-no. So that's something that we would certainly frown upon if we were investigating that. You shouldn't be altering a document after the fact.
I think this will give us a nice lead into this next question. Sean, could you talk about the impact that misuse or misrepresentation of service animals has on the individuals who rely on them?
Sure. I actually give you an example that happened not too long ago, and I've dealt with several, and it usually after discussion turns out great. But one of our clients with a service dog, actually her third service dog, walked into a restaurant in Noblesville with her service dog and was told she can't come in, but they'll give her food to go. She was there with her son, and her service dog Parker was phenomenal. So I went the next day and talked because it got heated, and part of it was her son raising it too, and they were insistent. And so I went the next day and had a talk with them, and what they said was, well, we've had two dogs in here recently. One dog defecated in our restaurant, and the other dog kept barking the whole time it was there. So I taught, gave them some documentation and about their rights and talked to them about, said, you're allowed to ask that dog to leave, but by law, you can't assume that's every dog. But that goes to the situation of how it affects the next client who then was told she can't come into a restaurant, and how does that feel to her as an individual with her service dog that is phenomenal, and that resistance or that, well, it was understandable on their part, but it was also against the law. So it really does affect the client that needs the service dog, that has an appropriate, a well-trained service dog, and it's not. Luckily, it's not common, but it's not uncommon that this happens. And I think Scott and Chase mentioned it, and what I can do is proactive in getting more and more education out there, hopefully is minimizing some of that. Because there's also cultural differences that they may jump to say no quicker because of one little instance in the restaurant or in the store, or as we're talking about it in a housing. So boy, does it affect our clients, and how do you think it affects how they feel to not having access to a place?
Thank you. All right, I have another situation. If pet fees and a pet deposit were charged while a reasonable accommodation request was pending, does a property management company's refusal to refund those fees after the accommodation is approved constitute a denial of a reasonable accommodation?
Here's the legal answer. Depends. So when did you request the accommodation? But yeah, that's certainly something that could be a concern for us if um, they're not refunding the deposit and you've made the request timely in advance beforehand. Um, in such a situation, you should not be charged a fee. So that if you were, it should have been refunded. So again, it's going to depend on the facts, but as just as a general rule of thumb, that's something we would definitely frown upon.
All right, I have a question for Chase. If someone believes they've experienced housing discrimination related to a disability or accommodation request, what should their first step be?
I would say probably compiling documentation. So for our investigations, they largely depend on being able to substantiate what is specific they are specifically alleging. So getting information as far as their recommendation letter, possibly confirmation in writing from their housing provider of the denial, anything showing that context and confirming those allegations would probably be the best first step in order to uh, show or substantiate their allegations. So I would say that would be a good start.
Thank you. And then, Scott, I am going to direct this one to you. Indiana housing providers are commonly requiring that the medical professional that is writing the letter for the animal to be located in Indiana and will not accept letters from out-of-state medical professionals. Can you speak further to this?
Yeah, that's something we're starting to encounter, and that's I think kind of the rule that is followed. We're still exploring that. As I think Chase mentioned earlier, we used to have some nice guidelines from HUD on applications, which they've removed. So it opened up a lot of issues. This being one of them. The other one being, of course, how many questions can they ask you? How much can they explore the issue? Even to the point where when we're asking questions during the investigation, people are getting upset. So it's going to be kind of just again fact dependent, but and it's somewhat up in the air at the moment, unfortunately. So we're waiting to get a kind of a definitive answer on that. But we have, in our case, if we have actual documentation, whether it's out of state or not, we often do consider it as part of that process that yes, there is a disability, yes, there is a need for the animal.
Thank you. All right, let's do another one for Sean. I know you briefly went over this during your presentation, but maybe you could speak a little bit more to it. For someone considering getting a service animal, what should they realistically expect in terms of training, time commitment, and responsibility?
Sure. For ICANN, and I will say virtually all assistance dog international accredited organizations, to fully train a service dog, it depends on the age you start, first of all. But if it's an older dog, you might get it done in a year. That'd be the quickest. We do 2 years. We actually are part of a breeding co-op throughout Assistance Dogs International, and we have our own breeding program, and we start them in the litter doing little things. And we train for 2 years, and they're out in public every 6 weeks with our volunteers for 3 weeks at a time. So it's a process, and what people have to understand right now, the average wait time, and it could depend. You could get placed quickly, or it could take, on average, it's a 1 to 3 year process, and normally it's on the 2 to 3 year end is normal. Now, the reason I said, well, you could get placed quickly is this isn't putting a square peg in a square hole. In a round hole. We look at your home environment, your work environment, your school environment, your lifestyle, and what skills you need, and the type of dog you need. Do you have kids? Do you have pets? Other pets. And we have to find the right dog for your needs and your lifestyle. And the reality is, ICANN right now has about a 54.5% graduation rate for every dog that goes into training, whether it's behavioral or medical. Internationally, it's about 51% for every 3 year period, because these are living beings that every dog we release and place with a home, they're like, this is a normal dog. Yeah, but it chases a squirrel, which would pull over somebody, and that's a issue. Or it wants to greet every person, that's pulling. Or it barks, which is normal for a dog. Those are automatic disqualifiers. So it does take time, and it's not about, okay, we're going to get this dog and we'll train it. That's a kind of a hot luck whether it works for you. We have to identify everything about that dog and you to make that match. So it is on average usually 2 to 3 years. Sometimes you get placed quicker. But looking into the process, and what ICANN does, and I actually think my client success manager is on here. What ICANN does is also recommend, hey, you may apply with us. We recommend you apply with other organizations too. Whoever can find that right dog. We're not here to, only go to us. We want you to get the service dog that you need. So we do encourage apply to other organizations because there is a waiting time to find that right dog.
All right, thank you. And looking at the chat here, I do see I work in Elkhart County. Does ICANN offer their veteran services in my county?
So you're close. So we do, it depends on the disability. Right now, as it's a fairly new, psychiatric service dogs were not recognized by the Veterans Administration until a couple years ago after they did a couple studies, or contracted out a couple studies. So to build the right program, we're in the 10 counties around Fort Wayne, around Allen County. If they go to the Fort Wayne, Northeast Indiana VA, it doesn't matter if they live outside those counties but they would have to come to Fort Wayne to train. We are going to expand. I'm not going to tell you when, because a couple of my team members on here, and they'd probably kill me. But if it's for mobility or any other need for a service dog, we do place throughout Indiana, but it's just psychiatric services right now. We're in the 10 counties so that we can build that strong foundation of this fairly new type of recognized service dog.
Thank you. All right, and then I'll direct this one to Scott. Can a landlord require tenants to take the approved emotional support animal off the property grounds to use the bathroom?
Yes, they can. So Again, it has to be a uniform practice. They can't just single out the assistance animal. Keep in mind, under the nuisance rules, the owner is responsible for the damage or cleaning up after their animal, but it has to be uniform. They can't just single out the assistance animal, as I said. They do have to make sure they are making a reasonable accommodations.
All right, we got some good questions. I do see one hand up. We do not have attendee mics on, so if you do have a question, please either put it in the Q&A or the chat, please. All right, can we call the doctor and only ask if the certificate was recently updated for emotional support animals? Our condo is thinking about asking for updated doctor's documents yearly for emotional support animals only.
As far as confirming that the recommendation is still current, would probably be reasonable to reach out and confirm with housing providers reaching out to confirm with medical providers.
Yeah, I would echo that.
So,
It is permitted if it's not obvious that there's still an ongoing need, but just to confirm that there's still a need for that ESA. It's just going to depend on how you go about it and making sure again that you're uniform in your application and you're not just singling out one person.
perfect. Thank you so much. It looks like we have gotten to all the questions, except one that I will take. Is a recording of this available? Yes, there will be a recording of this in the coming days, and I have that in my little wrap up that I'll do here in a second. I will just give you one more minute. If there's any other questions, go ahead and put it in the chat. If not, I will continue on. All right. Thank you for those questions. And as we begin to wrap up, I just want to emphasize that clear information and communication play a critical role in preventing confusion and supporting fair housing for everyone. If you're looking for more information or believe you may have experienced housing discrimination, we encourage you to visit ICRC's website, www.in.gov/ICRC. For those that could not join us today, the recording of today's panel will be available to watch in the coming days on ICRC's YouTube channel, IN Civil Rights. I just want to say thank you again to our panelists for sharing their time and expertise, and thank you all for your questions and for joining us today. Thank you.
All right. Thank you, everyone.
Thank you.